you have questions about your employment law rights that you need answered? Ask a Lawyer is here for you. Every week, Lecker & Associates disability and employment lawyers are taking your questions on a wide range of employment law topics. Call 1-888-802-2016 or send your questions to askalawyer@cp24.com. Watch Ask a Lawyer every Wednesday at 9:30 p.m. on CP24.
If you've ever had a question about your employment law rights, then you've come to the right place. Welcome to Ask a Lawyer, a call-in show where we take your questions about all things employment law. I'm your host, Dana Levinson. Each week, we dive into a different employment-related topic that is on many Canadians' minds. I'd like to welcome my two guests for today, Matthew Fisher, partner with Toronto-based law firm Lecker & Associates, and Jared Lecker, associate lawyer with Lecker & Associates. Today, we're going to talk about human rights and discrimination. As always, we'll be taking questions from Canadians. But before we get to your emails, Matthew, I'd like to talk a little bit about this topic because so many people believe they know everything about discrimination, but that's not the case.
People know the important element. They know that in Canada, in Ontario, and across the country, you're entitled to be protected in employment from discrimination and harassment. What people need to appreciate is that that protection, it's specific because discrimination can mean a lot of things. It simply means that you are being treated differently. It's not illegal to treat people differently, and we know that inherently. If your job is to be a goalie on a hockey team, if one goalie lets in more goals than the other, the team is going to discriminate. They're going to choose one versus the other. The discrimination that's illegal in Canada and in Ontario and all the provinces is when it's under a protected ground. These are grounds such as age, religion, sex, sexual orientation, disability. So to go back to the goalie, if the team determines they find out that the goalie is gay or they find out what religion he is from or they find out that he suffers from depression and they say, well, we don't want you on our team as a result, that's illegal discrimination. And for that, there's strong protections. We have our Human Rights Code in Ontario. We have the Canadian Human Rights Act for federal employees. There's a lot of protection, not only monetary protection, but protections that allow people in certain circumstances to be reinstated to their job or to get extra penalties against their employer for that kind of mistreatment, because we really look down on that in the law.
It's good to know that there's a lot of protection, and we have a lot of emails coming in. So if you have a question for our experts, call us at 1-888-802-2016 or email us at askalawyer@cp24.com. Let's kick things off by taking our first email. Carrie from Newmarket had this question for our experts. I recently found out that I'm pregnant. I told some of my close colleagues, but I haven't told my manager yet. In the past, my manager has made somewhat rude comments when other people have announced their pregnancies, talking about their extended vacations. I have heard rumors that the company is downsizing later in the year, and I'm worried about telling my boss that I'm pregnant. What should I do? Matthew.
You should tell your boss. I'll tell you why. Women who are pregnant, women who have babies, women who return and want to return to work after maternity leave have very strong protections in our laws. But the key, the starting point to that is if your employer is going to discriminate against you, they need to know. Now, here's the problem in the circumstance from that email. Employees will sometimes, they're excited, they'll tell their friends first. They'll tell their friends at work, they'll tell their colleagues. If a woman tells her friends and then a week later is fired from her job and says, well, this must be because I'm pregnant. The problem is that she may be left with a lack of evidence. The employer says, well, we didn't know. We had no idea. It's good to tell your employer as early as possible and in writing, and even print off a copy and bring it home with you. The fact that you're pregnant doesn't mean that you can't be terminated from your employment. What it means is that you can't be discriminated against because of the pregnancy. The pregnancy can't be all of the reason. It can't even be a tiny part of the reason. If it is, you have remedies under the Employment Standards Act. You have remedies under the Human Rights Code. Now, even in a circumstance where the employer didn't know, or a circumstance where the employer decided before, and they can show through evidence that your pregnancy was not the reason for the dismissal, it doesn't mean you don't have extra protection. The reason for that is when people get severance, they get what's called reasonable notice, coverage when they've lost their job for a reasonable period. We all know, practically speaking, if somebody's pregnant and they're let go from their job, what's the practical problem? Number one, they show up for an interview and they're more pregnant each day. It's going to be very hard to find a new job. Number two, with EI, they're going to start eating into their EI application, their period, early before their maternity leave begins, and they're not going to have a job to return to, which they were otherwise protected from if they were there until the end. The courts have recognized this. There have been recent cases where they've said, we recognize this, we acknowledge it's going to take a longer time to find a job, so you get extra compensation. This is really a circumstance you should not be thinking, I can take care of this myself, I'll deal with the employer. You have a lot of legal rights in this instance. They need to be protected.
You know, we could talk about mat leave for an entire show, but it is a real thing for women. They are afraid to talk about being pregnant, and they're afraid to take that mat leave because they're fearful that if a company is downsizing, they're going to be one of the first to go.
It's a real fear, and you hear it. Our laws do as much as they practically can. Inside, of course, people, they think about it when they're deciding how many children to have. How is this going to affect my career? It's real. You should realize, obviously, the law can't change everything. It's not magic, but it really works very hard to put women who have children in a situation to say, you will not be worse off at work. If you are going to be terminated anyway from your employment, that's one thing, but you cannot be chosen. I had a case a number of years ago where my client was let go during a maternity leave, and the employer explained in the hearing, well, we wouldn't have necessarily terminated her, but her replacement was great. The law is meant to protect that. She never would have been replaced had she not gone on maternity leave. And the employee won, and she got reinstatement, and she got back pay and damages because the tribunal in that case wanted to send a message. You have a right to go on a maternity leave. You will get your job back.
Okay. We're going to move on because I said we could talk about mat leave for the entire show. Our next question comes from Bernard in Mississauga. My manager jokingly mentioned to me that I have been working for a very long time and I should spend more time with my family. I'm in my mid-60s, but enjoy working and don't want to retire yet. Apparently, he was serious because he later told me the company will lay me off so I can take a well-deserved break with my grandkids. Am I being forced to retire? Jared, what do you think of that one?
Good question, Bernard. The short answer is there's no such thing as mandatory or forced retirement in Ontario anymore. Since 2006, there were amendments to the Ontario Human Rights Code that eliminated that provision in our laws. Since then, there were some policies in place that between the ages of 18 to 64 that allowed for forced retirement. But since this amendment and since subsequent case law that has come out afterwards, it's eliminated this provision or this permission to allow employers to terminate senior employees without severance. So the short answer is no. Bernard should ultimately consult an employment lawyer to discuss his severance rights, because it's very likely he's been targeted on the basis of his age and given a false narrative that he's too old to work, which is certainly untrue nowadays.
So is it true that people can work as long as they want nowadays?
Yes, I would say they certainly are able to work as long as they would like to, as long as they are physically fit. There are some exceptions for bona fide occupational requirements. If you're a firefighter or a pilot, you have to undergo certain physical assessments, but barring those exceptions, there's no mandatory retirement in Ontario.
Okay, we are getting off to an awesome show. Let's take a short break, and when we come back, Matthew and Jared from Lecker & Associates will answer more of your questions. Stay with us.
Do you have questions about your employment law rights that you need answered? Ask a Lawyer is here for you. Every week, Lecker & Associates disability and employment lawyers are taking your questions on a wide range of employment law topics. Call 1-888-802-2016 or send your questions to askalawyer@cp24.com. Watch Ask a Lawyer every Wednesday at 9:30 p.m. on CP24.